Well, good afternoon and welcome to everyone for this special lecture that's part of the McKercher lecture series. And it's also part of a workshop, a small workshop being held over today and tomorrow on Indigenous industry agreements. But we have this component as a public lecture component. And to introduce the guest speaker, though, I'm going to call forward Larry Ciaran, who's the Academic Director of the Native Law Centre here at the University of Saskatchewan, and he'll provide us a longer introduction to the event.
Thank you very much, Dwight. I'd like to first acknowledge the traditional homeland of the Métis Nation and Treaty 6 here on the university is on those territories, and it's important to acknowledge the Métis Nation and Treaty 6 First Nations whose traditional territory we occupy. As Dwight mentioned, I'm the new academic director of the Native Law Centre here, and of course the Native Law Centre is very much involved in promoting research on Indigenous law issues, publishing the Canadian Native Law Reporter and other books that relate to Aboriginal law issues. And so we're very interested in partnering with Dwight in this very important initiative. I also wanted to kind of briefly mention that the Native Law Centre is going through a kind of a revisioning phase, rethinking the purpose and mandate of this center, and we certainly look forward to feedback from those who are interested in Aboriginal law issues. And if you're interested, I did prepare a few copies for those who might be interested in looking at the revisioning process we're engaged in. There's a few questions to think about in terms of the objectives and purpose of the Native Law Centre. So just to let you know about that. I have the pleasure of introducing Ciaran O'Farquharly. Sorry, Ciaran. I knew I'd have difficulty pronouncing his name. He is a professor of politics and public policy at Griffith University, all the way from Brisbane in Australia. He has previously held positions at the University of Papua New Guinea, the Australian National University, and Queen's University. He has published numerous articles and books in the fields of public policy, policy evaluation, and policy implementation, resource economics and resources policy, negotiation, impact assessment, and Indigenous studies. So he's captured a pretty broad perspective on these issues. And for 25 years, he has worked with Indigenous organizations, both in Australia and here in Canada, on social impact assessments and on negotiation of agreements with resource development companies, and has acted as an advisor or negotiator for many of Australia's leading Aboriginal organizations, including the Cape York, Northern, Central, Yamatji, and Kimberley Land Council. So he's got a wealth of knowledge and experience in terms of both academic and scholarly inquiry into these issues, but also some practical experience as well. I also wanted to bring your attention to his latest book, which is very much on point with the workshops that are occurring over the next 2 days. The book is called Negotiations in the Indigenous World, Aboriginal Peoples and the Extractive Industry in Australia and Canada. It's a 2016 publication, and one that's very important in terms of issues dealing with Indigenous rights and resource companies wishing to exploit resources within Indigenous territories. So with a very welcoming to our guest from Australia, thank you very much.
Good afternoon. I also would like to pay my respects to the Aboriginal peoples of this land on which we meet, the Métis people and the Treaty 6 First Nations. I would also like to pay my respect to the many Aboriginal people in Australia and Canada who have shared their knowledge with me in the area that I'm going to talk about today. It's an area that's often sensitive, that's important, that can leave people politically vulnerable. So I especially appreciate people's willingness to share their knowledge. And without that knowledge, what I'm going to talk about today, I could not speak about. I've been asked to give a keynote address for the workshop on the law and politics of industry agreements. My understanding of a keynote address is that I should try and give you a sense of our current knowledge in the field. I should try and give you a sense of some of the big issues and the big areas for debate in the field. And I should also give you my view of our gaps in knowledge and where future research should focus. So I want to begin then by talking quite briefly about some conceptual perspectives on negotiation agreements. This isn't a topic that tends to occupy a lot of time. When people talk about negotiated agreements, the discussion tends to be a lot more hands-on. But I think it is important to understand some of the perspectives that people are coming from and talking about the issue. I also then want to move on and look at our state of knowledge in 4 key areas about negotiated agreements. Agreement-making processes, so what happens before an agreement is actually signed. The content of agreements, what do these agreements actually say? What do they do? What do they provide for? What do we know about this? Agreement implementation, I realized, having been involved in negotiations for 10 years, I realized that signing an agreement was a very different matter to making sure that what was provided for in that agreement actually happened. So I want to focus on that area. And ultimately, whatever view you take of these agreements, they must be intended in some way to affect the well-being of Aboriginal peoples, hopefully in significant ways. So I want to look at the outcomes of those agreements. If time permits, most of my work, as Larry mentioned, has been in Australia and Canada, but I am working now looking at the extension of agreement making to the global south. If I can, I'll say a few words about that and then touch on priorities for future research. I want to identify 3 broad approaches to looking at Indigenous industry agreements. The first one I refer to as contractualism. The focus here is on the structure and content of the legal documents that we describe as agreements, and issues related to their status and legal force. Now, this is the focus that most practitioners have when they talk about agreements. Negotiated agreements purport, and I say purport deliberately because there is some debate about this, purport to be contracts. So it's clearly important to have a focus on what's in these agreements, in the documents themselves, how they're structured, what form they take. And it's particularly important to focus on a number of issues that tend to figure largely in textbooks about contract law, but that have particular relevance, are particularly germane in the context of Indigenous industry agreements. They are issues such as genuine consent. It's one matter to establish whether an individual or a corporation has given its consent, but what about a, quote, community? How do we know when and under what conditions consent has been given to an agreement and whether or not it's genuine? There is a lot of controversy about this issue, both in your country and in mine. There are many cases in which issues are raised about whether or not a community has, quote, genuinely consented to an agreement. The issue of certainty of whether or not it is possible for a reasonable individual to assess what the parties to an agreement intended. Also very important and very relevant, especially given that these agreements are not always very specific in their terms, especially in the 70s and 80s when these agreements started in both countries. They were often quite vague in their language. That raises questions about performance and enforceability. So what does performance mean? If you make a commitment to maximize Aboriginal employment, for example, which many agreements do, what constitutes performance under those sorts of terms? Related to that, enforceability. Is it possible? Are these agreements genuinely contracts? If you go to court, will a judge enforce it? Is it possible? Is it certain enough to allow enforcement? All of these are very practical but critical issues. And there's a substantial amount written about them. However, in my view, this approach tends to assume wrongly that the legal framework operates equitably for all parties. That is a fundamental assumption. It's not the same as assuming that all parties are equally powerful, but there is an assumption that there's a legal framework that operates equitably for them. I believe that this is not the case, again, in either country, in Australia or in Canada. Related to this approach, I believe, downplays the issue of power, which in fact is critical when you come to looking at Indigenous industry negotiations. The second approach I want to look at, I describe as a hard structural approach. It includes ideas like neoliberal hegemony, like internal colonialism. And I raise it partly because it has become a dominant theme in the Canadian academic literature, and I want to stress academic literature, especially in the last decade. This literature argues that agreements are simply another vehicle for capitalist exploitation of Indigenous peoples and lands. It acknowledges that there is some improvement in terms of that the presence of Aboriginal people is now recognised, as it wasn't in the 50s and 60s, for example, by industry, but that essentially little has changed, that this is simply another vehicle for exploiting Aboriginal people. Government has stepped back, and that's why it's a neoliberal hegemony. Government has handed the reins to industry, but the exploitation continues. This literature emphasised the withdrawal of the state, the failure of the state to establish a policy framework for impact and benefit agreements, as these negotiated agreements are called in Canada, and that this leaves Aboriginal people vulnerable. It argues that confidentiality and lack of transparency of agreements and provisions prohibiting any opposition to projects disempowers Aboriginal people. Confidentiality agreements in particular are seen to restrict the exchange of knowledge, the free availability of knowledge, whereas industry, on the other hand, partly because some of the companies are very big and negotiate multiple agreements, partly because there's a lot of communication within industry, does have access to very good information about what's going on in the agreement-making area. Aboriginal people lack that. For this and other reasons, it's argued, there's a severe power imbalance affecting Indigenous parties, and that's why the end result is exploitative, and in this view, is inevitably exploitative. This approach draws general and very negative conclusions about impact and benefit agreements. And I have to say that this sort of statement characterises the academic literature in Canada generally, much of it, in the last decade, and not just the literature that adopts this very hard structural approach. In the paper that I've written as a background to this presentation, which, by the way, if you would like to have a copy of, I'm happy to send you if you leave your email. I document this in detail. I just have two short quotes here to give you a sense of where this literature is coming from. One, IBAs maintain and reproduce the state's historical role as an ally of the mining industry. So nothing's changed. It's the state and the mining industry versus Indigenous people as it's always been. Another quote, IBAs absolve the Crown of its responsibility to consult and accommodate Indigenous people, silence potential critics of mining development, and delays resolution of comprehensive land claims. The strength of this approach is that it does focus our attention very properly on power. The drawbacks with this approach, and I think they're substantial, are summarized in this slide. The first one is that most of its conclusions are reached without reference to the detail of any specific impact and benefit agreement, and the literature is self-referencing. So if you look at the sources in this academic work, the source for criticisms is often other articles written from a same sort of point of view. For example, in I think 2007, Kane and Krugman published an article which is critical of confidentiality clauses, and they are constantly quoted as by later articles as the source for the existence of problems around confidentiality clauses. Fundamental issue, and this is going to be a core theme in my address today, and I'm going to come back to it in detail. It can't explain the great variation that we observe in the content and outcomes of Indigenous industry agreements. I will come back to this. But if you look at the range of agreements in both Australia and Canada, there is a huge variation in terms of the balance of benefits that is provided to Indigenous people. Now, if they are correct, if IBAs are simply an exploitative tool, you should not get this. It should not be possible to get one agreement, as we'll see, that is highly favourable to Aboriginal peoples, and another agreement that may be actually detrimental to them. It treats IBAs in isolation, yet in both Canada and Australia, a critical consideration in the way Aboriginal people combine IBAs with, for example, land claims, litigation and EIA processes. And you can't understand the significance of IBAs unless you understand the way in which they are combined with these other processes. But this literature ignores that. Let me illustrate what I mean with a specific example. Over a number of years, the Innu and Inuit people of Labrador negotiated with Inco, which was then the owner of the Voisey's Bay mine. They were involved in IBA negotiations, which were not getting very far. In 2001, they prevailed on the Newfoundland and Canadian governments after delaying the project through a series of court cases to sign an interim land claims agreement. That land claims agreement said that no titles would be issued for Voisey's Bay until Inco signed IBAs with Innu and Inuit. This completely shifted the balance of power. That project could not proceed until an agreement was negotiated with the Innu and Inuit. The result was one of the strongest impact and benefit agreements negotiated in this country. But you cannot understand the significance of that impact and benefit agreement unless you understand what was happening in these other forums, in the courts, in negotiations with Canada and Newfoundland. And neither can you understand it unless you realize that at the same time, the Innu and Inuit negotiated environmental management agreements with Newfoundland and Canada, which gave them major roles in the environmental management and planning of that project to such an extent that they were able to bring about a reduction in the scale of the project from 20,000 tonnes a day to 7,000 tonnes a day. I'll give that example partly to illustrate my point about linking different areas, but also to illustrate my point about the potential significance of these agreements, because we are not talking about marginal adjustments here. We are talking about changing the scale of a project and so its whole environmental and economic and cultural footprint. The final point, the treatment of the role of the state appears contradictory to me. It's seen as an ally of capital, but it also calls for the state to create a policy and legal framework for IBAs. Now, if the state is an ally of capital, why the heck would you want it creating the policy framework for IBAs? The third conceptual approach I term soft structural approach. This is represented, for example, by critical realism. For reasons that I'm happy to discuss if we have an opportunity, this approach is much more common in the Australian literature, which doesn't tend to be characterised nearly as much by that hard structural approach you get in Canada. This recognises the power of structural forces. It doesn't argue that neoliberalism, the withdrawal of government, privatisation, all of these major structural factors are at play, but it regards them as trends or influences rather than as forces that determine in a hard way what the outcomes will be. It argues that the context will affect the way in which these broad trends actually come to play in particular situations. And this context, and to me this is a key point, this context includes the exercise of Indigenous agency. It acknowledges that Indigenous people are powerful actors, or can be, in particular contexts, can be powerful actors in terms of shaping outcomes. Whereas one of the very depressing implications of the second approach is that if everything is so structurally determined, there is nothing that Aboriginal people can do about it unless they overthrow the capitalist system, which is a bit of a tall order. Okay, let's move on then to look at the state of knowledge in some of these specific areas. I want to begin with process issues. Process issues are absolutely critical. It is very obvious from any sort of systematic work in this area that community engagement in particular, the extent, the quality of community engagement has a huge impact on shaping negotiation outcomes. One of our speakers this morning, who's an experienced negotiator in Canada, indicated that they spend 80% of the time on internal negotiation, his term, but that is very much about getting your processes sorted out within a community, defining what it is that you want, what are your priorities, what are the different interests in your community that need to be reflected in negotiation. Is it possible to achieve compromise within the community? There are always a range of interests, just like in any community, any Aboriginal community I've ever worked with. There is a wide range of interests in relation to major extractive projects. If you go to the negotiating table and you haven't sorted out those interests, and it doesn't mean that you solve conflict, it means that you recognize, that you document that range of interests, and you seek to accommodate them. You seek, for example, to accommodate the interests of people who are focused on jobs through having strong employment provisions. You seek the interests of elders who are more concerned about looking after country by having strong environmental management provisions. You find out, and it's not often easy in Aboriginal communities because young people can defer to elders, you find out what's important for young people and you try and accommodate them. You try and make sure that women's voices, which are not often easy to hear quickly if you are using quick and dirty consultation methods, you make sure that there is time, that there is opportunity to hear the voices of women and to make sure that they are playing a major role in the negotiation. A particular approach that has been pioneered in Australia, but I notice it's being used much more extensively in Canada now, is what we call community-controlled impact assessment. And that involves actually carrying out your own impact assessment of a project, or alternatively taking over the Indigenous component of a statutory environmental impact assessment and going through an extensive and thorough analysis of the likely impacts of a project, identifying the interests that will be affected and bringing them into the picture. So widespread commentary in Canada about the claimed inadequacy of community engagement processes, not just in that literature, the academic literature I've talked to you about, but much more widely. And I'll come back to this at the end, but I think there is a need for systematic work on getting proper criteria to assess the quality, the legitimacy of community engagement. There's a great deal of discussion about these issues, but a paucity of work that actually tries to develop measures that we could use and apply and say what constitutes best practice in terms of community engagement. Timeframes, another critical aspect of process. If timeframes are too tight, too short, this can create huge problems in terms of getting the sort of community engagement that you need. In Australia, and I'll come back to this, unlike Canada, we have national legislation which recognises Indigenous inherent rights in land. It creates a framework for negotiating agreements, but in the first instance it allows only 6 months for negotiations between industry and Indigenous people. After that, industry can go to a government tribunal and seek to have titles for a project issued. 6 months is much too short. There is no way in the world that you can prepare properly, that you can engage with a community on complex issues in that time frame. And that's hugely problematic. But those sorts of constraints can arise in other ways as well. Funding, very major issue. Generally, in Australia and Canada, Indigenous people have to rely on industry funding for negotiations. Unless it's handled properly and rigorously, that can create major issues because, quite simply, at the critical point, industry can threaten to withdraw funding. I've been involved in a number of negotiations where industry has done that, has tried to use the threat of withdrawing funding to force through agreements that were not acceptable to the community. There are strategies that you can use to deal with that, but it's a process issue that requires considerable attention. Confidentiality, huge issue in Canada, seen in the literature as anti-democratic, as reducing bargaining power, as I said, because it restricts the Aboriginal side. Controversial also, I think, in part because of the linkage created in the literature and by some analysts between the duty to consult, the constitutional and court-mandated duty to consult, and the negotiation of IBAs. That implies that there is a public element to impact and benefit agreements, and so why should they be private? Why should they be confidential? Interestingly, this is much less of an issue in Australia. I think that's partly because of the difference in legal regime, because we don't have that duty to consult issue. But also I think because there is a very clear boundary drawn between two aspects of confidentiality in Australia, which I notice is not nearly as clearly drawn in this country. In Australia, there is a very clear distinction between confidentiality in relation to the Aboriginal population, to the community, to the peoples who are being asked to sign this agreement, and confidentiality in relation to the wider public. Restrictions on access to information at that first level are simply not acceptable in Australia. I'm not saying that they never happen, but the norm is that a community must always have full access to the complete text of an agreement, to all its provisions and information about their implications before there is any attempt to have them sign it. That doesn't mean that there isn't confidentiality as against the wider world. That's, I think, an important distinction to make in the context of this literature. The final point I want to make there is that I think that the literature underestimates the sharing of information among Aboriginal groups. There is a lot of information that is shared. And I think that the literature, people not involved in this area, certainly underestimate the effectiveness of Aboriginal networks, both within countries and across countries. I've personally been involved in facilitating 2 exchanges of groups of Aboriginal people between Australia and Canada, whose sole purpose was to effect an exchange of information about what's happening in agreement making between Indigenous people and industry. And I know that that sort of information happens on a much more informal level much of the time. Let's turn to the content of agreements. So what is in these IBAs? What does it tell us about whether or not they are beneficial or detrimental to Indigenous people? My impression as a negotiator was that there was a great deal of variety and variation from agreement to agreement. So, for example, in some agreements, there were restrictive clauses, for example, on confidentiality. There were no objection clauses saying that a community, every member in a community was barred from doing anything to object to a project. In other agreements, these sorts of things were missing. Huge variation in the extent of economic benefits, and there still are. There are agreements in Canada for major projects where the total financial benefit to the community is well below $1 million for the whole life of a project. There are other agreements which have royalties equivalent to the level achieved by provinces in Canada or states in Australia. This is a huge difference, a huge variation. The degree to which mitigation measures add to existing legislative provisions also varies greatly. Some agreements simply say that the company will obey the law on protecting culture, the law on protection of the environment. Other agreements will add greatly and very significantly to the extent and the nature of environmental protection and to the role of Aboriginal people in affecting that protection. So, my question was, how do we explain this? To try and understand what's going on here, I felt it was important to develop explicit, rigorous criteria for evaluating the provisions of agreements. How do we know what is a good agreement from an Aboriginal point of view? There's a lot of general discussion about this in the literature, but there was nothing, to my view, that really allowed you to try and nail this down across these different areas. And based on developing those criteria, we needed a study of a large number of impact and benefit agreements in different Aboriginal legal and industry contexts, if we were to explain why it is that you get this great variation. And so, over a number of years, I worked on this book, which was published last year. Mercifully, it is about to come out in paperback, which hopefully will make it accessible to more than university librarians. And what I did here was that I identified 7 key areas of industry Aboriginal agreements: cultural heritage protection, participation in environmental management, revenue sharing or royalties, Aboriginal employment and training, business development opportunities, land use, land access and recognition of land rights, and very importantly, agreement implementation. Much else depends on this. I'm going to do this very quickly because it is documented in full in the book. I'm not going to go into all of the methodology. I just want to do enough of it to give you a sense of how I went about it. I developed numeric scales, quantitative scales for each of these 7 areas that could be used to measure the extent to which a particular agreement promoted Indigenous interests. To the extent that an agreement scores towards the top of the scale, it's a, quote, good agreement in relation to the relevant issue. For example, from the many years that I'd spent working with Indigenous people, from my work with them as a negotiator, from carrying out community consultations, in the area of the environment, there were 2 linked interests that Aboriginal people had. The first one is to have the greatest possible control over identifying and managing environmental impacts and over project design and operation that shape these impacts. The second was to minimize the environmental impacts of mining. Indigenous control was essential to achieve this, as state agencies and mining companies cannot be relied upon to do so. Now, this is documented extensively in the book, but for the Aboriginal people I worked with, they simply do not believe that either corporations or the state, if left to their own devices, will protect their traditional lands. So the critical issue for them is to be in control of defining and managing environmental issues. So I developed a scale to assess the extent to which agreement provisions delivered on giving them that control. The scale, as you see here, goes from -1 to 6. Why do I need a minus score? I need a minus score because some agreements actually limit people's exercise of rights that they have under legislation. There are agreements, for example, that say that Aboriginal people will not exercise their rights as citizens to object to the level of environmental assessment that has been set by the regulatory authority. Now, if that's all an agreement says, you're actually worse off than you had if you had no agreement. So there has to be a minus score. 0 is no provisions. 1 is that the mining company commits to comply with environmental legislation. Why does that matter? It matters because it gives Aboriginal people standing at common law, contractual standing, to sue a company if it does not obey the law. Now, you might say, well, of course they obey the law. No, they don't. In both our countries, there are many cases, and there are companies in Canada at the moment that are being fined heavily for failing to comply with environmental law. So this is a real, a substantive provision. The company undertakes to consult with affected Aboriginal people. Difficulty there is, of course, there's no requirement on the company to do anything once they have consulted. Third one is that Aboriginal parties have a right to access and independently evaluate information on environmental management. That's important because how do you know what's actually going on? How do you know if the law has been broken if you can't access information? But the next 3 are situations in which we shift to joint decision making. So number 4, Aboriginal parties can suggest ways of enhancing environmental management, and the operator must address these issues. So now there's a requirement to do something. 5 is joint decision making on some or all environmental issues. 6, Aboriginal parties have the capacity to act unilaterally to deal with environmental concerns or problems. So as you go up through the scale, Aboriginal people have a stronger and stronger capacity to take control of environmental issues. Now, I'm not saying that this scale is perfect. I'm not saying that you can minutely calibrate it. But it does allow us to start looking at any agreement and to place it on a scale and to get a sense of how effective it is in terms of meeting this objective. I then looked at 45 agreements across Australia, projects for all major mining regions, different legal regimes, companies, sectors, etc. I analysed each agreement in detail and awarded it a score on each of the 7 key issues. This confirmed that outcomes vary enormously across agreements. In some cases, Aboriginal people are possibly worse off on balance than with no agreement, very few benefits, and they undertake not to exercise their existing rights. In other cases, no limitations on existing rights, strong cultural heritage, environmental protection, substantial economic benefits, recognition of their title, return of land to them. Enormous variation, a huge difference between the weakest agreements from an Aboriginal perspective and the strongest agreements. Why? Very important and obvious question. It's not trade-offs. One obvious question is that some people are more interested in money, some people are more interested in protecting the environment. So they trade off money against stronger environmental protection. They accept a low result on the revenue side to get very strong protection. That's not what's happening in Australia, according to this study, according to these 45 agreements. What you find is that agreements tend to be weak across the board or strong across the board. Now, I can illustrate that by indicating where these agreements fall on one scale, from 1, which is the weakest, to 45. So I picked the environmental management scale. So at the bottom is the agreements that are -1. And then I'll go up to the agreements at the top, which are 6. Now, when you do that on one scale, this is what you get. The red cells are strong outcomes. This is the environmental result. And what you find is that almost everywhere else the outcomes are weak too. If people are getting a bad result on the environment, they're getting a bad result. This is the bottom 25% of the 45 agreements. If you look at the top 25%, you see you get exactly the opposite. So the people who have a 4 or 5 or 6 on the environment are also doing very well on the money side, on cultural heritage protection, on employment and training, and so on. So it's not trade-offs. It's not company size or industry sector. I included big companies, small companies, different parts of the mining industry. It's not company size. Some of the strongest agreements are with medium-sized companies. There is an argument that bigger companies have greater infrastructure in terms of pursuing a social license to operate, have a greater incentive to pursue a social license to operate, so they should have better agreements. There's no evidence of that. There's no evidence that it's company policy. Inevitably, because of the concentration in the mining industry, my sample of 45 agreements from every major resource producing region employs some companies with multiple agreements. So in this sample, there's a company, there are 2 companies, one has 5 agreements and one has 4. Those companies, you won't be surprised to hear, are BHP Billiton and Rio Tinto. BHP Billiton and Rio Tinto have agreements in the top 25%, and they also have agreements in the bottom 25%. Now, if company policy was driving this, you should not get that result. Now, you might get some squeeze, you might get, the top one and then the next one, but if you have them at the top and the bottom, then clearly it's not corporate policy that's running this. The legal regime is important. You'll see that a lot of these agreements here are negotiated under the Native Title Act. As I explained, the Native Title Act puts Aboriginal people in a very difficult negotiating position, because if there's no agreement in 6 months, they're straight into a government tribunal, and history shows that the government tribunal will give the company its title. If that happens, the tribunal will not award people any compensation related to the value of the minerals in the ground. In other words, they cannot get a royalty. So there's huge pressure on people to do the deal if it goes to this tribunal. So we're not surprised to find that there are a lot of weak agreements. And I think this has major implications for the debate in Canada about whether or not you want government setting the framework for IBAs. I know that Australia has a different legal regime. I know there are differences and significant differences, but on this evidence, you do not want government anywhere near setting the framework for your IBAs. However, puzzling, the 3 strongest agreements are also negotiated under this weak legal regime. Policy-based agreements are situations in which there is no legal requirement to negotiate. So even where some people have no legal rights to an IBA, they're in the top 25%, and the 3 strongest agreements are negotiated under this weak legislation. So what's going on? What's happening is easy to illustrate once we actually put all these agreements on a map, which is, as you see, of Australia. It's the 45 agreements. As I said, I picked them from all the major resource producing regions in the country. They're represented here on the map. When you look at the strongest ones, that's where they are. Now, what's characteristic of these regions here? What's characteristic of them is that they all have strong land-based regional Aboriginal organisations. The whole of Australia is divided up into land councils, but the ones up here are grassroots political organisations that support individual groups of traditional owners, as we call them, when they negotiate with the mining industry. That means that they get access Traditional owners get access to financial and technical resources to support their negotiations. These organizations can make credible threats of direct political action if industry is not coming to the table in a reasonable way. They develop a strategic approach to using environmental impact legislation, administrative law, mining law, very much along the model that I mentioned to you that the Innu and the Inuit used. And, of course, it's no coincidence that both the Innu and the Inuit also had strong pre-existing land-based organizations before those negotiations with Voisey's Bay. And they developed strategies to build precedent from agreement to agreement. So you'll see that some of these agreements are in clusters. And what they do is that they negotiate this one, they build on that to get this one, they build on that to get this one, and they gradually build up precedents, they establish precedents, they work those into the next agreement, and so on. Now, I have spent too long talking about outcomes or the content of agreements, so I'm just going to briefly mention a couple of other things that are discussed in detail in the paper. Implementation is a different area because here we do know a lot. First of all, we know that there are major problems with non-implementation, both in Australia and Canada. I published a paper as long ago as 2002 in which I documented chronic non-implementation of agreements in both countries. We understand why that happens. The agreements themselves, vague language, failure to quantify goals and set timeframes, absence of financial and human resources specifically dedicated to implementation. So I don't mean money for employment and training, I mean money, personnel to actually focus on making sure that things are happening. Failure to clearly identify responsibility for implementation actions, and review and amendment clauses that are formulaic and underutilized. There are also broader issues, high turnover among responsible project and community staff. Mining companies tend to turn over their senior staff at least every 3 years. Within 3 years, every mining company person involved in negotiating an agreement is usually gone somewhere else. Huge issue in terms of continuity, institutional memory, and so on. Lack of attention from senior decision makers, competing demands on project time, lack of administrative resources in Aboriginal communities, lack of cultural competencies in companies. So this is an area where we know a lot about the problem and we know a lot about what needs to happen. Where we need more research is on the mechanisms to make that happen. And I think particularly on what I call self-executing mechanisms. What I mean by this are mechanisms that kick in automatically if there is a threat of failure, implementation failure, or a threat of implementation failure. I discuss in detail in the paper one example of what I mean by a self-executing mechanism. In one agreement I was involved in negotiating, there are 3-year targets for Aboriginal employment and training. If the target is not met, the base Aboriginal employment and training budget increases. The bigger the gap between the target and what's achieved, the bigger the increase in the budget. If targets are not met for 2 periods in a row, the budget escalates very substantially. Now, this happens automatically. That's what I mean by self-executing. But very importantly, mining companies are obsessed with cost containment. Because they live in an industry that's cyclical, their costs have to be in the bottom quarter, if at all possible, so that they survive when the price goes down. So they're extremely focused on cost containment. If you get a blowout in a budget for Aboriginal employment and training, managers sit up and they take notice. And they start asking why. What's going on? Well, we haven't achieved our targets. Why haven't we achieved our targets? And that's what you need for implementation, to actually get people to focus 5 years, 10 years after an agreement on what's going on. I'm going to have to wrap up. As I say, I'm very happy to send people the full paper, but I do want to just finish on the slides where I focus on what I think are some areas of particular importance for future research. Further analysing this high degree of variability between individual agreements. especially helpful to replicate an analysis of a large number of IBAs using explicit criteria in the Canadian context. We don't have anything equivalent to my study in Australia in Canada. It would be extremely useful, given the different legal context, different history, different issues that occur in this country. It would be very helpful in terms of explaining outcomes, because there are some things that are comparable, there are some things that we can hold constant, but there are some things that are different. And it would be really useful if we could have a comparable study and see, well, what's happening in Canada? We know that you get the same sort of variability. Sorry, we know that you get variability, but is it the same? Is it for the same reasons? If it's not, what are the factors at play? I think developing explicit and quantitative criteria for assessing the processes used to prepare for negotiations is extremely important. It's such a big issue in Canada. It seems to me that in this country, it's an area that really deserves a lot of focus for researchers. Research to identify ways of ensuring more effective implementation of agreements, especially a focus on those self-executing mechanisms. Rigorous evaluative studies of the impacts arising from the economic, environmental and cultural heritage provisions of agreements. I didn't get a chance to cover that part of the talk, but my bottom line message was we know very little about the ultimate impact of these agreements on Indigenous well-being. There are very few studies that actually track through what is happening after 5 years and 10 years. What is it doing to the well-being of the community? But ultimately, that is the single most important question to ask. Everything else is leading up to that question, but there's almost no research that focuses on it, and we need a lot more. And finally, agreements are spreading to the global south. They are showing a lot of the characteristics of Australian and Canadian agreements. We have a paper on agreements related to land development at this seminar, at the workshop. It shows very clearly many of the characteristics that Australia and Canada has displayed in an earlier generation of IBAs. It would be really good to start now setting up research to monitor agreement making in the global south as it spreads and as it matures. Thank you again for coming. Thank you for listening to me. Particular thanks to Dwight Newman and the Law Centre for the invitation to come and the invitation to talk to you about agreements. Thank you.
There's 5 minutes for questions if anybody has a question.
Well, thank you very much for the lecture. I'll push on a global health aspect. I think the title of your lecture is Opportunities and Challenges. So where do you see opportunities and challenges for the global south, and namely if the kind of governance, capacity, ability to mobilize politically is the key findings to explain positive, strong outcomes in the Australian case, what sort of features would we expect to see in parts of the global south? Where might you see that? To what extent is this a story about democracy, about strong institutions, about presence of civil society, etc.?
I think in the global south, some of the obvious challenges are the absence of the rule of law. If you are in a country and in a culture where you believe that the courts are controlled by the government and are not going to back you up in any sense if you have an agreement and the company doesn't comply with it, it's very hard to focus on agreement making. It makes much more sense, it's much more rational to do what people do, which is to act directly, to protest, to blockade, and to try and extract what are often simply lists of benefits from that situation. I think another challenge is the use of violence against Indigenous peoples. In both our countries, there is, of course, a history of extensive violence against our Indigenous peoples. But for the most part, and I say for the most part, that's not an issue that Aboriginal peoples have to deal with today. I mean violence by the state, from the state. In much of the global south, that's still a very big issue. So I think there are two of the big challenges. On the positive side, there is a very substantial capacity to mobilize and to act directly in the global south. And to the extent that that can start to be redirected, that energy and that capacity, because I believe that in Australia and Canada, it is actually the capacity to mobilize that's the critical factor. That final slide I had with where the strong agreements are, those land organizations can mobilize. They can mobilize resources, they can mobilize people. And the Innu and Inuit did exactly the same thing. I mean, they closed down that mine site 4 times during the negotiation process. So I think one of the strengths is that amazing capacity to mobilize. Another strength is that ILO 169 has been signed by many more countries in the global south. The IFC and the World Bank is involved in funding projects in the global south, whereas they're not in Australia and Canada. So their safeguards provide another way in. So I think that there are some negatives, but let's not forget the negatives in Australia and Canada. Australian and Canadian Aboriginal people in economic terms are poor, they're marginalised, they face institutional discrimination, they have faced violence in the past, they face racism on a systematic basis, yet they are still able to achieve some very strong agreements. So I think we have to put the problems of the global south in that context. There are such cases, there are agreements that provide for that in Australia, certainly. I'm not aware of any situation where it's actually been put into effect in terms of an arbitral body outside. There are cases where agreements have been enforced in the courts. And in most cases, though, the alternative dispute resolution comes through relationship building. So the Aboriginal people I work with in Australia see agreements very differently to most of us in this room. Most of us in this room, I assume, being lawyers or law students. And Aboriginal people see it as much less of a landmark. They see it more as one stone along a long path of many other stones. And so to them, it's all about a relationship. There's a diamond mine in Western Australia called Argyle, which had a very unfortunate start and a very, very, very poor exploitative division-creating agreement back in 1980. And for 30 years, the traditional owners for Argyle negotiated with that company. There was never a negotiation. There were never lawyers appointed to represent each side. But they negotiated with the company. They negotiated by turning up to the company offices and demanding things and complaining about things and offering things, offering, for example, to perform cultural ceremonies to protect the workers in the mine. They negotiated every day, every week for 30 years. Now, then, Argyle's a Rio Tinto company. Rio Tinto had a conversion on the road to Damascus. In 1995, they decided they were going to negotiate agreements with all of their communities. 2001 to 2005, they put a huge amount of effort into negotiating this huge agreement. And they documented everything, crossed every I. The day after the agreement was signed, a bunch of Aboriginal people turn up and they say, we want to talk to you about X. And the company says, but it's not in the agreement. And they said, and? So that's more the alternative dispute resolution that happens.
That wraps up the keynote event for today. I want to express our deepest thanks for